After 7 decades of caste-based reservations, a bill has been passed that caters to the economically weaker sections of the society. The 103rd Constitutional Amendment has provided 10% reservation in government jobs and educational institutions to those who are economically weak among the upper castes or forwards, or those who are not covered by any reservation. On January 25, the Supreme Court said that it would examine the quota. However, it has not stayed its implementation immediately. This is an unprecedented move, as historically in India, caste and not economic class has dictated the way quotas are allotted. To understand why our constitution makers favored caste over economic class for reservations, we need to keep in mind the unique role that caste plays in our society.
The basic principle being that because you're socially and educationally backward and so underrepresented, that you are naturally, economically, extremely backward. And the other assumption being that if you are a forward caste, your ability, your connections, the fact that you had social acceptability and not that exclusion, you'd find it much easier to make your way up.
So, it was necessary for the Constitution to recognize its existence and make provisions for the advancement of the scheduled castes and tribes. During the British rule, the decennial census, held since the late 19th century, institutionalized caste as the foremost social division characterizing India. Movements to fight against caste discrimination started before the British left India. In 1935, B.R. Ambedkar fought for separate electorates for the depressed classes, now grouped under the name Scheduled Castes in the Government of India Act. In 1950, the Constitution made way for caste-based reservations in independent India. Article 46 of the Constitution states, "The state shall promote with special care the educational and economic interests of the weaker sections of the people, and in particular the scheduled castes and scheduled tribes, and shall protect them from social injustice and all forms of exploitation." Article 330 and 332 give special benefits to these groups in the form of reservations in the Lok Sabha and state legislative assemblies. In 1951, the census lists were used and the state decided that 55.3 million people, which was 20% of India's population, would be included under reserved categories. In 1954, seats were reserved for the scheduled castes and scheduled tribes in educational institutions and jobs in the public sector on the recommendation of the Education Ministry. In 1979, the Mandal Commission, set up by the Janata Party government, listed out those castes who were not included under SC/ST. They were called the other backward classes. In 1992, the Mandal Commission's recommendation to provide 27.5% reservation to the other backward classes was implemented. In 1992, P.V. Narasimha Rao's government proposed a 10% reservation based on economic status. This was never approved by the Supreme Court, and a cap was put on reservations at 50%, reiterating that no reservation can be made on economic criteria. In 2008, the Kerala government under Chief Minister V.S. Achyutanandan wanted to reserve 10% seats in graduation and post-graduation courses in government colleges and 7.5% seats in universities for the economically backward among the forwards. This appeal is still pending in the Supreme Court. In 2011, Mayawati, then Chief Minister of Uttar Pradesh, wrote to the central government asking for reservation for upper caste poor. In 2008 and 2015, the Rajasthan Assembly passed bills to provide a 14% quota to the economically backward classes among the forward castes. None of these attempts, however, have been successful.
The scope of striking it down got reduced because it is not an executive action, it is not even a legislative action, it is the highest you can have in a legal system, that the provision now finds a place in the Constitution itself. Now, a constitutional amendment is generally upheld. It is very rare that a constitutional amendment is struck down. When this amendment will be challenged, the inquiry of the court will be much limited. Now, court has to see whether this economic reservation violates what is called basic structure of the Constitution.
There are several petitions before the higher judiciary challenging this move, and the fate of the quota remains to be seen.